Dear speakers, dear guests that watching us online, my name is Roman Nekwaliak. I work as an International Relations Coordinator at the Center for Civil Liberties, and today I will be your moderator. Today, in the framework of Ukrainian Criminal Justice Week, we hold a webinar dedicated to the analysis of the international criminal justice system. Today, we will speak about the crime of aggression, the establishment of the International Tribunal, and the possible future amendments to the Rome Statute, which will enable the effective prosecution of Russian crime of aggression against Ukraine in 2022. Our distinguished speaker today is Professor David Donat Katen and Ms. Frederica Shvegoforova. They will address the topic of the crime of aggression in respect to the establishment of an international tribunal and in respect of the amendment of the Rome Statute jurisdiction to allow the crime of aggression to other core atrocity crimes. David Katin is a former Secretary General of the Parliamentarians for the Global Action, global international NGO, the largest global NGO of individual lawmakers, policymakers, and parliament members worldwide. And Ms. Frederica Shvegoforova is a current International Law and Human Rights Program Director at the Parliamentarians for Global Action. So you can ask your question in the chat, or you can raise your hand in Zoom and voice them by yourself at the Q&A session. The video will be recorded and you can rewatch it for your educational purposes afterwards. Mr. Katin, the floor is yours. Thank you.
Thank you very much, Roman, and it's really an honor for me to be part of this International Law Week with the Center for Civil Liberties, an organization with which I had the privilege to work in my previous capacity when I was with PGA, who today is very well represented by Frederica, since the Euromaidan changes of 2014 and the role that CCL played as a major human rights actor, also as a steering committee and creator of the Human Rights Agenda network of Ukrainian NGOs, well before the work that you are undergoing now under a Tribunal for Putin project. I'm talking today as an academic. I teach international law at NYU Center for Global Affairs, as well as law of international organizations at University of Verona. I will try to give an introduction to the crime of aggression, its definition and the conditions for the exercise of jurisdiction before the ICC, as well as its status under international law. And Frederica will then present more precisely the position of parliamentarians of global action, including the proposed amendments to the Kampala amendments of 2010. As we know, the Rome Statute had its 25th birthday 4 days ago on Monday. The Rome Statute creates a system of international criminal justice to which, unfortunately, Ukraine is not yet a party. So notwithstanding the fact that Ukraine is the place where there are the largest ever investigations carried out by the Office of the Prosecutor, because we know that Mr. Karim Khan not only has already issued an arrest warrant directed against the president of the Russian Federation and the Commissioner for Children's Rights of the Russian Federation. But my understanding, and I may be totally wrong because what I know is just information that is not corroborated, but in my understanding, as of the time when the arrest warrant was issued, there were already 9 parallel investigations on very serious international crimes committed in Ukraine. And I do believe that with the destruction of the dam in, I believe, Novakovka, if I'm pronouncing correctly, there is a 10th one ongoing as reported by the media. So we are looking at least 10 cases and at least maybe 20, 30, 40, 50, 60 persons to be indicted, to be charged. Now the ICC has indicted 40 people in its lifespan of about 22.5 years. So only in respect of the Ukrainian conflict, we're looking at maybe more than that. So we have to understand that either now or never. I mean, it's time now for the Ukrainian government to join the ICC. It's really absolutely irrational. I really don't understand if there were reasons or concerns about security, if there was a lobby by the Trump administration for Ukraine not to join or things like that. They need to be overcome. Recently, in respect of the crime of aggression, there was a major initiative at the European Union level with Eurojust and the European Commission creating an international center for the prosecution of aggression based in The Hague, which is not only an EU-Ukraine and its allies initiative. Ukraine is part of it, of course. But the United States Department of Justice is co-funding it with the European Union. So if the United States doesn't want Ukraine to ratify the Rome Statute, I don't understand how can then fund a body that is collecting evidence that may end up also, before the ICC. So it is what it is. I think this is really political what I'm saying now, and I take full responsibility. I think, now or never, because certainly the Russian Federation is ongoing an absolutely illegal war of aggression against Ukraine. In my personal view, the Russian Federation has already lost the war because it aimed at toppling the government in Kiev. It aimed at occupying the second largest city, Kharkiv. It aimed at doing things that it couldn't do, simply because Ukraine is a sovereign nation with the ability to defend itself. There are a lot of territories still to be liberated, of course, and this is ongoing, and it's a tragic war whose responsibility must be fully squarely put in the realm of the leadership of the Russian Federation. And that's why the crime of aggression is so important. None of the war crimes or the crimes against humanity, or eventually even episodes of genocide that could be attributable to the responsibility of Russian individuals would have not taken place in the absence of the decision by the leadership to launch a war of aggression. So in other words, the crime of aggression in this type of situation of an international armed conflict caused by a decision to launch a war of aggression, the crime of aggression encapsulates and comprehends all the other crimes. And in fact, if you read the statement issued by Prosecutor Khan on the 27th of, I must rectify myself. If you listen to the statement by President Mansky of the ICC on the 27th of March, when the arrest warrant against Mr. Putin was made public without it being published, because it's not yet published, but there is some sort of a statement summarizing it. The ICC said that this crime of deportation of children, for which the charges are issued, happens in the context of a war of aggression. And as we know, there is no war of aggression until and unless the leaders decide to launch it as a criminal act. So the crime of aggression comes before the act of aggression, like an act of genocide comes after a criminal decision to undergo a genocidal policy, or an attack against a civilian population takes place as an act of state after that the criminal decided to target that unlawful target. So what we are discussing today is really the most relevant and important crime in the framework of the ongoing conflict, which is victimizing so many people. The crime of aggression is defined under international law only recently, because yes, we had predecessors, and I want to address here the questions raised by one of your participants. The Bryan-Kellogg Pact between World War I and World War II was about the renunciation of war by the powers that were involved in World War I, but did not attach individual criminal responsibility to the perpetrators of a war of aggression. So when Nuremberg came, the International Military Tribunal set up in Nuremberg on the basis of the London Agreement of 1945, This was the biggest innovation because we could find traces in the development of international law of the notion of war crimes since the 1907 Hague Convention, as well as crimes against humanity. One may argue, as some scholars do, that in the post-World War I treaties, you had the notions of violating the law and the dictates of humanity, you had the Martens Clause, you had a number of provisions. But on crimes against the peace, or now crime of aggression, yes, it was unlawful to launch a war of aggression, but it was not criminal. So this was a major innovation of the Moscow Declaration 1943 and the London Agreement 1945, which the United Nations General Assembly declared as part of customary law as early as 1946. So there is no doubt that today there is individual criminal responsibility for crime of aggression. The problem was that the Nuremberg definition, this was declaring that aggression is aggression without essentially giving a penal law definition. Crime of aggression is waging, launching, executing a war of aggression. So this was the biggest topic given to the International Law Commission, which in the 1950s started to draft a draft code of crimes against the peace and security of humankind, or mankind at that time. And only in 1974, as an echo to those negotiations, the General Assembly was able to agree upon a definition which, however, did not meet the threshold of the principle of legality, because while it enlisted a number of acts of aggression for the purposes of attributing the responsibility of the state, the aggressor state, there was a final clause stipulating that any other act that the Security Council would determine that it falls under the definition of aggression is aggression. So as you can understand, under penal law, you cannot leave to a political body to determine whatever it could be punishable, because it wouldn't meet the principle nullum crimen nulla pena sine lege, the certainty and predictability of the law. So the 1974 definition wasn't done for the purpose of individual criminal responsibility, it was done for the purpose of state responsibility, even though the title of that famous UN General Assembly resolution was definition of the crime of aggression. When in 1998 the Rome Statute was adopted, it was an easy job for those opposing the incorporation of this crime in the Rome Statute to say there is not an agreed definition. And in the 5 weeks of the Rome Conference, it was not possible to agree on such a definition. And therefore, the compromise was to leave it listed in Article 5, but the reference was made to a first review conference that should have taken place 7 years after entry into force. And such a review conference was tasked with the mandate to adopt a definition and the conditions for the exercise of the court jurisdiction. So that's what we had in 1998 in Article 5. There is jurisdiction of the ICC on aggression, but such a definition and condition for the exercise of jurisdiction should be determined 7 years after entry into force. The Kampala conference took place 8 years after entry into force, to our unpleasant surprise, but anyway, took place, and concluded itself with a consensus decision on a definition, which is now reproduced in Article 8 bis of the Rome Statute, as well as consensus agreement on certain conditions for the exercise of jurisdiction under Article 15 bis and ter of the Rome Statute. These amendments were ratified by more than 30 states as of 2016. In 2017, the Assembly of State Parties agreed to activate the jurisdiction of the court on this crime, and the jurisdiction started to be active on 17 July 2018. What are the major features of the definition and of the conditions for the exercise of jurisdiction? The definition of the crime is contained in the paragraph 1 of Article 8 bis, and it stipulates that this is only a crime that can be committed by leaders, by those who are exercising effective control on and decision-making in a state apparatus. So not the direct perpetrators, but those who give the orders, make the planning, and take decisions on the execution of the plan. The crime has to be a manifest, grave, and in terms of scale, severe violation of the prohibition of the use of force under Chapter 7 of the United Nations Charter, and should reflect in terms of actus reus, in terms of acts, any of the conduct listed in the paragraph 2. Now, only the most severe, manifest, and in terms of scale, grave manifestations of these acts of aggression are punishable as such as crimes. So when we look at the list of the paragraph 2, which essentially reproduces the same list of prohibited acts of states under Resolution 3314 of the 1974 UNGA resolution, in my humble view, it is only the first conduct, the first act that falls squarely in every situation under the definition of the crime. And this regards the invasion by one state in the territories of another state for the purposes of occupation, annexation, or change of regime. So when this happens, there is no doubt that we have the act of aggression as a consequence of the crime of aggression, which must be the gravest conduct performing these violations of the prohibition to use force in international relations. When we look instead at the other acts of states, bombardments, use of territories of other states, the sending of armed bandits, armed bands, or mercenaries, or the use of a territory of one state for the purpose of attacking another state, then what we need to see is that we need to verify whether these illegal uses of armed force against international law, in violation of Article 2.4 of the UN Charter and corresponding to what the Security Council would have normally defined as an act of aggression under Article 39, which regretfully the Security Council fails to determine because it's driven by power politics. And as we know, even when Saddam Hussein Iraq invaded, occupied, changed the regime, and annexed Kuwait into Iraq in 1990, the Security Council was only able to say it's a breach to the peace. It didn't call it aggression, because the Council is, again, a political body that regretfully in many situations do not apply the law. And in fact, Russia, with its veto, is able to block any action by the Security Council in the situation in Ukraine, as it did already, by the way, in the situation in Syria, where equally large war crimes and crimes against humanity took place for a long time frame. And probably the impunity that the leaders of Russia received during their campaign in Syria emboldened their will, their criminal will, to do what they are doing now in the territories of Ukraine. So what this brings us to conclude is that the definition, albeit not as extensive or progressive as one would have wanted, is solid enough to let us consider that what is happening in Ukraine today, prima facie, fulfills the criteria for the application of that definition. So in my humble view, would there be a jurisdiction exercising its powers under either the Rome Statute or a special tribunal applying Article 8b's definition? I have no doubt that such a definition would apply to the current situation in Ukraine, especially because of the underlying conduct of Russia pretending to occupy and annex in addition to carry out widespread and systematic attack against the sovereignty in terms of territorial integrity and political independence of Ukraine. Why the court cannot exercise jurisdiction if the Rome Statute amendments entered into force on the 17th of July 2018? Simply because in the absence of a Security Council referral, which, by the way, under Article 13b and Article 15 ter, when there would be such a referral, there would be a unity of the norms pertaining to the 4 core crimes under international law. So the referral, without any qualifications, would send to the jurisdiction of the court any crime committed in a given situation, namely war crimes, crimes against humanity, genocide, and crime of aggression after the 17th of July 2018. Any future Security Council referral would do that job, because it's not the job of the Council to tell the court what crimes are committed. The job of the Council is to simply indicate what the situation is that threatens the peace and security or constitutes a breach to the peace or an act of aggression under Article 39. Therefore, bringing to justice the perpetrator can help restore international peace and security. That's the job of the Council. The Council has nothing to say on who gets prosecuted or not, on whether the court ascertains that there is aggression or not. And there is a no prejudice clause, both in Article 15 ter and 15 bis, saying that the court is not conditioned by the determination of any political body whether aggression has occurred or not. Whether Ukraine or the UK or the US or the EU or any government says it's aggression, it doesn't, or even the General Assembly of the UN, it doesn't matter to the court. The court is totally independent court that only applies under Article 21, the Rome Statute, is only bound to apply the law and not political decisions or determinations. Okay, but unfortunately, the Security Council does not want to refer the situation of Ukraine to the ICC jurisdiction because of Russia's veto, which is an abuse of power. Russia, being in conflict of interest, should abstain from participating in deliberations in the Council on this matter, but it violates a general principle of international law, nemo iudex in re sua, nobody can be a judge in its own case, and therefore abuse of his right of veto against this situation. So what we have to look at is Article 15 bis, about the proprio motu, or state referral triggering of an investigation before the court. And here we have a big problem, because the state parties to the Rome Statute in Kampala agreed to the US request to create a carve-out, an exception to the nationals of non-state parties who are excluded from the jurisdiction of the ICC, as well as when an act of aggression is conducted making use of the army of a state non-party. So given these two exemptions under Article 15 bis paragraphs 4 and 5, which the PGA proposal aims at deleting, but Frederica will present it in detail, regretfully now, even though Ukraine accepted the jurisdiction of the court under Article 12.3, the court can only exercise jurisdiction on war crimes, against humanity, and genocide. These, however, in my humble view, can be modified by way of amending the Article 15 bis. The alternative would be to create a special tribunal. Let me be very honest here and fair to everyone here. Of course, having a special tribunal would be better than nothing, because we cannot allow impunity for crime of aggression. The problem is that this is not the first example of aggression in the history of humankind, and there is a large segment of the international community that views the situation of Ukraine as creating an imbalance or a double standard where, you know, because the victims are Europeans, we are now finally doing what needs to be done under the international law. And when the victims were African or Asian or from another continent, well, the international community didn't or would have not moved the way it should have. So the goal of amending the Kampala amendments would be to ensure that any future aggression, not only the one against Ukraine, would be punishable when and if committed by nationals of non-state parties. In that sense, it would send a message to these states that the law is applied equally to all. Now, we know that, you know, in history, when you make changes, you need to make sort of revolutions or, you know, drastic changes to the law, and not necessarily everyone will be treated equally. But thereafter, we need to give a guarantee that everyone will be treated equally before the law. So there has to be that bold decision, and I'm happy to say that 4 days ago at the UN, when the state parties to the Rome Statute met to celebrate the 25th anniversary of the statute, the foreign minister of Germany, the foreign minister of Liechtenstein, and high-level delegates from Austria, Estonia, and I would hope other states, but these are the ones that I can report on, they announced that it is time now to amend the amendments. So giving a very strong signal that they are ready to move forward. What is missing is an actual proposal to be deposited with the UN Secretary General, which needs to be circulated at least 3 months in advance of the Assembly of State Parties, because the Assembly of State Parties is the legislative body within the Rome Statute system. And under Article 121 of the statute, only after that any proposal is made public and given to states for at least 3 months, that proposal can be discussed and decisions can be taken and deliberations can be moved to action. So in the absence of a timely deposit of such a proposal, whatever the proposal, of course, Federica will present the PJ1, which I believe is the best one on the table, but in the absence of a concrete proposal, these are just speeches that has been made, wonderful speeches, which we applaud, but what we need now is concrete action. So I will stop here. I hope I have covered a lot of stuff with the most simple possible terms, and then we can come back in the second round to more specifics. Thank you. Federica.
Yes, Federica, please.
Thank you very much. So this has been an excellent introduction. So I will go probably straight to the proposal, and then maybe I will go back to the question of the special tribunal and also all other possibilities. So exactly, as David just mentioned, the issues of the Rome Statute are that there is this Article 15.5 bis, which creates a huge imbalance in terms of the alignment of the jurisdictional regime of the crime of aggression with the 3 other crimes. And obviously, this was a result of political conversations and to make sure that the potential aggressor states would not face justice in case that they would become Rome Statute parties. So our proposal aims at partially aligning the jurisdiction for the crime of aggression with the other 3. Not fully, because we are aware that it would not gain the political support, but it would be basically to remove this Article 15.5 bis, which actually, 15 bis 5 paragraph, which excludes the ICC jurisdiction of the crime of aggression over non-party states. So as a result, it would enable the court to try a non-party state officials, such as in this case, Russia, if it committed the crime of aggression on a territory of a state party which has accepted the jurisdiction on the crime of aggression. And what is very important to note, for the reasons that I just mentioned, this proposal would not affect the current jurisdictional limitations concerning the states parties that have not accepted the jurisdiction over the crime of aggression. So it's basically, in Realpolitik, we have several countries that would oppose it because there are Rome Statute states parties. They have not accepted the Kampala amendments on crime of aggression, and they would not like to be affected by this by this proposal. So that's why our proposal is worded in a way that it would only affect non-party states. And it is also, of course, for obvious reason, in this current situation. And the way we would like to proceed is quite unique because one of the criticisms that has been actually raised is that, okay, if we amend the Rome Statute, it will take too much time. There's this 1 year period after amendment enters into force. So our proposal also suggests that the states would, those that have ratified the Kampala amendments on the crime of aggression, would invoke an article of Vienna Convention Law of Treaties, which is Article 58.1b. And this article enables states to suspend an operation of a certain provision. It's only temporarily. And there are few conditions. So this suspension doesn't even have to be provided in the Rome Statute, in the treaty. So it is a law of as long, I mean, without explicit reference to the treaty, if it's permitted, if such suspension is not prohibited by the treaty, but also if it does not affect the enjoyment by the other parties of their rights under the treaty or the performance of their obligations, which would not be applicable because it would actually only be it will be invoked by those states that have already ratified the Kampala amendments and would not apply to those that have not. And then the second cumulative condition of this Article 58(1)(b) is that such suspension would not relate to a provision, the derogation from which is not compatible with the effective execution of the object and purpose of the treaty. And it's obvious, of course, that alignment of the jurisdiction is actually in compliance with the object and purpose of the treaty, because now we have a completely imbalanced system where we can try the crime of genocide, but not crime of aggression committed against the same country, against the same state, against the same civil population. So this is obviously against the current regime as it is now, is not compatible with the object and purpose of the Rome Statute. So after invoking, and this article would be invoked in relation to this article in the Rome Statute that stipulates the 1 year entry into force period, which is 121(4). So this would be removed, and this would be actually approved. It will be voted. It will be adopted by the Assembly of States Parties. So raising legitimacy because it will be adopted by the states parties to the Rome Statute. So this article on the entry into force would be removed, temporarily suspended. So this amendment on removing articles, so going back to the first one, removing Article 15 bis paragraph 5, which excludes the ICC jurisdiction over non-party states, would enter into force immediately. And it would be understandably adopted by those states parties that have accepted the jurisdiction over the crime of aggression. I was personally also thinking about invoking another article of the Vienna Convention, which is 41(b), and that actually enables agreements to modify treaties between certain of the parties only. So 2 or more of the parties can actually agree to modify the treaty. So obviously this would be a little bit easier way out because it wouldn't have to go through the procedure. But we've discussed this, and it's true, this could be perhaps challenged or not really agreed with, because it could also, it wouldn't create, or we wouldn't gain so much legitimacy as going through the states, Assembly of the States Parties, and would be more risking the fragmentation of the international law. I mean, of course, already the fact that we have amendments and only some states have accepted them, it's not really very positive in terms of fragmentation, but it's true that this could formalize it a little bit more. There is also another alternative, which is way more direct, and that's that the ASP, the Assembly of States Parties, would decide on the immediate entry into force of the amendments on Article 15 bis 5, which excludes the jurisdiction over non-party states. So this would basically be the fastest way, and it would still be legitimate because it would be decided by the Assemblies of States Parties. And now, again, it's, as I mentioned, we are hopeful, and actually several states have already expressed their support that it would be acceptable by all states, even those that have not ratified the Kampala amendments, because they would not be affected by this amendment. So exactly as David mentioned, in order to make this happen, such a proposal for amendment first needs to be tabled by a state, and it has to be done by the by the end of August. And I mean, we'll see what happens. I know that it has gained momentum, and it's definitely a more cost-effective and an efficient way to ensure the jurisdiction over the crime. And maybe going to the bigger picture and taking a step back, at this moment, and this is why there are, in my view, only basically two options how to make sure that the perpetrators and of the crime of aggression face justice, is either to make this amendment to the Rome Statute. By the way, there is another proposal that I just wanted to mention that has been suggested. I don't think that it has really gained appropriate momentum, but it's to amend the Rome Statute so that the UN General Assembly could refer the crime to the ICC. So instead of the UN Security Council, which of course is not able to act on this. So this is another proposal that has been suggested. So definitely it's an interesting one too. Apart from it, basically the other option would be to create a special tribunal. And I know that there have been a lot of conversations as to whether this should be a hybrid one or should be an international one created by the UN General Assembly, or it should be something similar to Nuremberg, which was only basically an agreement among certain states. And I would just very, very briefly go through these options. So if we look at the hybrid model, and I know it really depends in which way this would be created. A hybrid model, I know that there is, well, to start with, it's not possible to create it within this period when Ukraine is under martial law, because this would require a constitutional amendment, which is not possible to be passed during the martial law. So I would say that probably the whole conversation about the hybrid one as I understood it, is actually is a moot point. But in any case, there was another point that I really wanted to address, which is regarding the immunities. And one of the arguments was that such hybrid court would actually would apply immunity. So there would not be this irrelevance of official capacity as we have under the Rome Statute and as we should have under this special tribunal. And I just wanted to mention an example of the Kosovo Specialist Chambers, which actually, I mean, it's a hybrid court. It's an extension of the Kosovo domestic jurisdiction. And it was created in an interesting process with a lot of support by the EU. It was following the report by the Council of Europe Parliamentary Assembly. It also issued a resolution, and that triggered a joint investigation by the Council of Europe, the EU, and also local authorities under EULEX, which was the EU mission on the rule of law in Kosovo. And then this resolution also created a special investigative task force, which then conducted these investigations. And after several years, it turned into tribunal because it was conducted at actually a lot of evidence, sufficient amount of evidence was collected, and trials could be conducted. And Kosovo then passed a constitutional amendment. There was new law passed. There was also, I know the exchange of letters with the EU is also part of this whole package as to how that actually formed the creation of the tribunal, of this hybrid court. And the Kosovo court actually also includes in its Article 16 a provision on the irrelevance of official capacity of perpetrators. So it also, and as it has been in practice, it has the competence, the jurisdiction to try officials at the highest levels, so the immunities do not apply. So I just wanted to mention also this example because I feel like it hasn't necessarily gained enough attention, even though I appreciate the reasons why maybe international court would be preferred by Ukraine. But of course, the hybrid one, it has in the past had few additional, I would say, positive aspects or benefits. It respects the it's closer to victims. It respects the culture. It also implements the law of the country. So it also often actually is conducive to higher legitimacy and acceptance, which we don't need at this moment, of course, but in the past, it has been the reason why this option was actually preferred. As to the International Court, the suggestion is that this would be created by the UN General Assembly, which of course, well, I support. I mean, it has worked in the past. There was also this the Special Court in Sierra Leone, and also the ECCC on Cambodia. So basically, although there was actually a hybrid one, but it was also created with the UN. I mean, basically, yes, this is probably the best option as it seems now. There are no hurdles when it comes to legitimacy with the constitution of Ukraine. And I would also, according to the arguments by Ukrainians, this is actually something that would trigger the highest credibility in terms of the jurisdiction. And as the last option, this is what I alluded to before, is to create something similar to the Nuremberg Tribunal, which is actually a treaty between interested states creating a special tribunal. So it would not be after the UN General Assembly following a resolution, but it would be just among states. And of course, this could be also an option, but we could face concerns of allegations of selectivity, and also it would be, in the past, also the Nuremberg Tribunal, of course, irrespective of the great jurisprudence it has delivered, but it has been criticized as victors' justice. So as things stand, we supported the creation, the special tribunal following the resolution by the UN General Assembly. Of course, it has to act complementary to all other recourses to justice. So, of course, the ICC, hopefully, after the amendment is passed, but of course also complementary to the other crimes that even now are investigated by the ICC, then of course complementary to all other recourses to justice. So using universal jurisdiction, the ongoing trials in other states, and of course, importantly, domestic trials conducted by Ukraine. Of course, we know when it comes to the domestic trials by Ukraine, there are certain shortcomings because of the legislation. Ukraine doesn't have the jurisdiction over, well, it doesn't have provisions on crimes against humanity in its criminal code. War crimes are also not fully implemented or aligned with international standards. So we've been working together with our colleagues and also CCL on amending this, on the adoption of the law, and the law was adopted in May 2021, but it was never promulgated by the president. And then there was a subsequent initiative, which was tabled, which curbs certain of the provisions that are highly relevant. But at the very minimum, of course, it does implement the provisions of crime against humanity, and also implements the war crimes. So we would suggest the adoption of this law, even though there are highly problematic provisions on the command responsibility, because it really weakens this very important principle where the commander can be held liable if he knew or should have known in his capacity of the crimes committed and did not act to prevent them. And this newly proposed initiative, the legal draft, the bill, actually removes this should have known, and it really weakens significantly this very important principle. Nevertheless, this bill has not been moving forward. So as things stand, the domestic trials conducted by Ukraine may suffer from certain
we may have a small internet connection problem.
Maybe.
While we waiting Frederica reconnect, David, may I ask a question because it's addressed solely to you. On your personal opinion, what is the best scenario for Ukraine and the worst scenario with regard to the present Russian aggression, prosecution of crime of aggression?
Best scenario is that Ukraine ratifies the Rome Statute and its amendment, and at the same time proposes to amend the amendments together with Germany, Liechtenstein, Italy, and all the states that have spoken in favor, and then goes to the Assembly of State Parties in December to obtain this decision. When this decision is adopted, it can immediately add to the prosecutor office, at least from the 17th of July 2018, the jurisdiction on the crime of aggression regarding Ukraine. So it wouldn't cover 2014, the annexation of Crimea. It wouldn't cover that initial phase of the war. So it's not a perfect solution, I understand that. But in my view, it would be the most linear and cost-effective, and the one that would not raise any objection from the states that currently are either abstaining or against the special tribunal. Because in the UN system, Russia and China, they can block. In the ICC statute, you only have South Africa, Brazil, certain other global South members who can be not so happy of doing things. But if it's done within the ICC, I think they would support it. So I think realistically, this is the best scenario. When this can be activated, it can take totally from now 9 to 10 months. In less than a year, everything could be in place and the prosecutor can have the jurisdiction. Now, of course, that means a lot of diplomatic work, which is now currently with the excellent work done by Ambassador Anton Kornichevich, done around the idea of a special tribunal created with an agreement between the United Nations and Ukraine based on a United Nations General Assembly resolution. And again, the problem here is not, the plan is good. The problem is, are there more than 100 and plus votes to get the assembly in line with this policy? So I'm not sure. I'm not sure, because some major powers are at the UN and some certain powers like India, they don't want to support this for other reasons, which are domestic reasons. So there are complex geostrategic and political issues. These crimes are committed by heads of states and government. And some of the lawyers at the UN, they are behaving as if they are the defense lawyer of their heads of states. So they wouldn't do anything good for Ukrainian victims if they think that it could become a precedent that maybe some victims elsewhere can use against their head of state. So they don't act as diplomats. They act effectively as defense counsel. And it's very difficult to make them change their mind because they're not rational. They are like driving their positions to follow a state policy, to follow a personal, not a state policy, a personal policy of the head of state who wants to use the state for that purpose. So it is a very complicated situation, much more than some people believe, whereby those who have already ratified the Rome Statute, they cannot have those policy prevail. So I think that, in my view, that would be the best way. But yes, Federica is back. But I think at the end of the day, somebody must really talk to President Zelensky and give him really alternative options to what he's pursuing now. Because let me comment on one thing that Federica said about Nuremberg. Nuremberg was a military tribunal set up by the Allied powers through a treaty, the London Agreement, which was then submitted to the UN membership for ratification, and it was ratified by more than 40 states. At that time, the UN had only 49 members. So, so they knew that, doing new law means put a new treaty. An agreement between the UN and Ukraine, the Special Tribunal for Sierra Leone was backed by the Security Council. So it's new. It's something new that needs to be done. It can be done, but politically speaking, for this to happen, you need more than 100 states to vote in support, to be on the safe side. And it's not true that the 140 that condemn the aggression are ready to make a vote similarly. We have seen it with the resolutions at the UN on the reparations, on the, on the payments to be given to Ukraine. The numbers have been much lower of states in support of those measures, not to mention sanctions. How many states are sanctioning Russia? Only the EU, United States, Korea, Japan, Canada, Australia, but nobody, not even Turkey, which is a UN member state, is sanctioning Russia. So we are entering in a field of lawmaking that it's much more problematic. So I don't think there are the votes for a new Nuremberg. And remember, Nuremberg was created after that Germany and Italy and Japan were defeated. So, the situation is different. There is no new Nuremberg possible, in my view.
So, and to follow up on what you just say, the other participant asked, how soon the aggression can be punished if it's not linked to the victory on the battlefield? How soon such tribunal can be created or such mechanisms can be put in place?
How is it possible that there was a drone hitting the pinnacle of the Kremlin 2 months ago? This was crazy. When I saw it on TV, I couldn't believe it. Because first of all, if there was a real drone trying to hit the Kremlin, why on the pinnacle? You should have gone downstairs to try to hit some real bigger objective. Am I correct? So there is something strange going on in Russia. We have seen it also with the Wagner attempt to revolt or whatever. So anything can happen, but the law should follow its course. You apply the law, and then you enforce it when it's practicable and possible. So many people are investigated for murder, and they never get arrested, but you still investigate the murder case. Am I right? So we shouldn't be discouraged. We should not think that fully fledged victory is conditio sine qua non for the application of the law. And another story is whether there is a new regime somewhere and things can change, and you never know what can happen on the ground. You just apply the law as best as you can. So I don't think the two things are connected today. It's not like during World War II, where essentially after World War II, the option was either to execute the Nazis or to bring them to justice, or maybe to just forget and forgive and forget. So, Stalin and Churchill, they wanted mass executions. But Franklin Delano Roosevelt and the United States imposed the Nuremberg model, which was excellent because it's our civilization to bring to justice those who commit crime and not just execute them, as unfortunately it's allowed. It was allowed at the time under the law of war, the law of armed conflict. So I think it's a complex assessment that one makes, but I think the law should not be deterred by the fact that it's difficult to enforce it. We should just go ahead in a principled way, and alignment will come after. History will always side with those who are just and fair. That's my belief, and one has to pursue that vision, so to bring about change in a sustainable way. And if I can say something else before we finish, let me also say that the United Nations General Assembly referral is not possible, because the United General Assembly cannot make legally binding resolutions, because a referral on a territory, creating jurisdiction on a non-state party national or territory, as Chapter 7, as the UN can do under Chapter 7, is not possible, because if there is the consent of the territorial state, certain measures can have certain effects. But the court has to apply Article 21, and under Article 21, if the statute is not providing for a certain feature, it's not applicable. And then it has to be also dependent on applicable treaties and customary law. So it's really an avenue that it's I would say impossible from a legal point of view.
My huge apologies. I feel probably I was disconnected of speaking too much about the ways how to bring the perpetrators to justice, and this was and maybe not aligned with the place where I am now. In any case, regarding the UN General Assembly, there is this possibility or suggestion to amend the Rome Statute accordingly. But also, what's interesting is that it could act in line with the Uniting for Peace powers, actually. So sometimes, I mean, the UN General Assembly, if the UN Security Council faces an impasse or it's not able to act, then the UN General Assembly can actually take over. And this is probably the idea that it can actually assume some powers. I mean, it hasn't really been used in this regard yet, but it's also an option where we could see the ways out of the current situation, which makes it impossible to make the referral by the UN and without, yes. But anyway, this will also require amendments. So in my view, it will be also just much more, for the future, it will be also much more, let's say, sustainable to make the amendment as we proposed by PGA. Thank you.
Federica and David, thank you. And David, thank you for explaining how Security Council referral work to our participants, because we have one of such question in the chat. If I may, I have two more theoretical questions about the amendments, and maybe Federica is the best person to tackle them. First question, would an amendment of Article 15 bis 5 allow the court to prosecute the crime of aggression when the alleged perpetrator is a national of a non-consenting, non-party state? And what is your thoughts about indispensable third-party principle?
So as I explained in our proposal, this actually would be the purpose of it. And this is exactly why we have it would be aligning as with all other crimes. Also the short answer is yes. It would be a non-consenting, non-party state. Russia is a non-party. It would not consent to the jurisdiction, but this is also absolutely in line with the jurisdiction of the other three crimes. So the ICC is conducting investigations against Russian perpetrators, even though Russia is a non-consenting, non-party state. So when it comes to non-party states, it would align with these other three crimes. So yes.
David?
Let me just say that in addition, it's very important that we also delete from Article 15 bis the 7 words of paragraph 4 that block the jurisdiction of the court when an aggression is made with the use of an army of a state non-party. Because the proposal aims at deleting both languages, the entire paragraph 5 and those 7 words, so that it becomes clear that nationals of non-state parties are not exempted. And this would realign the jurisdiction of the court to the letter and the spirit, or the object and the purpose of the statute, which is to put an end to impunity for the 4 crimes under international law. So crime of aggression is not less important than the other 3 core crimes. And therefore, that's why the Vienna Convention should be suspended, because to the contrary of what the Vienna Convention prohibits, it would be a measure to suspend the entry into force provision of the treaty and make these immediately enter into force for those who accept the jurisdiction of the Kampala amendments, binding on them. This would realign the object and purpose of the amendments to the object and purpose of the statute of 1998. So it will let's say it will restore the Rome spirit versus the Kampala deviation. Kampala deviated from the object and the purpose of the statute, which is to end impunity for all the crimes, for political reasons. So the states who made that mistake can fix it. Now, it doesn't fix entirely the problem, as Frederica correctly said, because under Article 121, paragraph 5, already in Rome, there was a provision stipulating that for those who do not join the Rome Statute as adopted in 98, when new crimes will be added or new jurisdiction will be added, as in the case of aggression, it's not a new crime, but it's new condition for exercise of jurisdiction are added to the statute, then if they are a party accepting the jurisdiction on the other crimes, by not accepting the new provisions, they would be exempted from the jurisdiction. So it creates an asymmetry which is in favor of non-parties joining the statute after 7 years, so that they can, somehow freeze the law for their advantage. So it's not ideal, but it was decided in 98, and we know that in the law, in international, there are some provisions that incentivate universality of a treaty, creating some privileges for those who join the club vis-a-vis those who are out of the club. Think about the UN. The UN Chapter 7 applies to all states. When Switzerland was not a UN member state, when Taiwan is not a UN member state, they still are bound by Chapter 7 resolutions. This seems unfair. It's not unfair. It's provided by the treaty. It's accepted by all, including by Taiwan, by Switzerland, when it was a non-member state. So that's the way international law is. And also domestic law, it's the way it is. It's not perfect. So our proposal is not perfect. I'm talking about us because I was a member of those who drafted it when I was with PGA more than a year and a half ago. It was March. We drafted this as early as in March 2022. And the idea is really to make sure that we use the ICC. Now, the really logical aspect of all this is Ukraine not being part of it. That's really where there is a missing element of the puzzle. Because if Ukraine was a member of the club, sitting in the assembly would say, here is what Ukraine wants, then I don't know who would say no. Nobody will say no. But because Ukraine is not inside, they are lobbying from outside. And some people are saying, why are they doing this? What is behind their strategy? Is Ukraine maybe interested in counter-aggressing neighboring countries? Is Ukraine interested to use prohibited weapons? Is Ukraine willing to commit crimes itself? Which is not the case, because Ukraine is a law-abiding nation. So I think this is where I would really come up, and I think the CCL can be the leading NGO once again on this topic, as it has been for many, many years.
Dear David and Frederica, thank you. And please, I will ask the last question because it's highly relevant. So the crime of aggression happened not only in 2022. As we know, from 2014, from the occupation of Crimea, Russia conducted war against Ukraine, and Ukraine was in the international armed conflict. And how to deal with the crime of aggression? It's not like a two crime of aggression happening. It's a prolonged violation of international legal order. How paperwork will done with regard to period from 2014 till 2022 till today?
So, unfortunately, under the Rome Statute, I cannot really, even if we amended it, I can't see how this could be and of course, yes, I know, yes, this is absolutely, the aggression has been going on since 2014. Because the crime of aggression was adopted only in 2017 and entering into force in July 2018 at the ICC, by the Assembly of States Parties of the ICC. I can't see a way how the crime of aggression could be tried before this date by the ICC. However, by this tribunal, I think this would be something that actually there had been already some proposals that would actually date the jurisdiction, the territorial jurisdiction, the temporal jurisdiction to 2014. So I think this will be possible. I mean, you know, it's basically as with other special tribunals or international courts, and including the Nuremberg that we talked about, the temporary jurisdiction would go back. So this would be actually possible by the international court.
I agree with Federica, and you know, sometimes the best is the enemy of the good. So even if it would be ideal to prosecute the entire criminal pattern, I would say that 100% there is no doubt that crime of aggression was committed, since if you prosecute from 17th of July 2018, you can already encapsulate the continued occupation of Crimea from that date before the fully fledged invasion, and then look at the fully fledged invasion and make a very strong case. So, you know, by prosecuting from 2018, in my view, you cover what happened in 2014, because it's a permanent crime. As long as the occupation and annexation continues, it's the same crime that started in 2014. So it would be, in my view, not the ideal, but a very satisfactory prosecution before the ICC when amended.
Dear David, dear Federica, thank you for navigating all these questions. And we are ready to finish. I will remind the participants that today, together with Professor David Katin, Professor of International Law at New York University, and together with Federica Schweihoferova, a specialist of Parliamentarians for Global Action, we speak about international crimes and the establishment of International Tribunal. Dear participants, thank you for your active participation, and stay tuned, learn IHL with us. Together today, we will host 2 more events. In less than 1 hour, we will speak about the establishment of a special tribunal at 4 o'clock Kiev time, and 6 o'clock Kiev time, we will speak about the core atrocity crime, the crime of genocide. We are ready to finish. Thank you for your presentations.
Thank you. Bye-bye. Thank you.
Thank you very much. Thank you. Thank you.